So before the short adjournment, I was addressing differences between freezing injunctions and normal American cyanamid interim injunctions. And I discussed the point that the interim injunction is giving you a previous or an early vindication of the right that you're seeking at trial, unlike a freezing injunction. Another distinction is that in the interim injunction, American cyanamid context, the court is called on to assess the balance of convenience when deciding whether or not to grant the injunction, whereas there is no such evaluation on an application for a freezing injunction in terms of balancing the convenience of each party, which one can see makes it harder to decide whether or not there is a winner in an American cyanamid situation, unlike in a freezing order situation where the successful applicant has demonstrated that they have overcome the jurisdictional hurdle.
Well, I'm afraid I don't understand that. Suppose you have an interim injunction and the argument is all about whether the merits threshold has been met or not. And the defendant says, I entirely accept that if the merits threshold is met, the balance of convenience is in favour of granting the injunction. I can't argue against that. And argues and fails on that. The fact that as part of the jurisdiction, you have to establish what is undisputed on that occasion. What happens under the balance of convenience? Why does that make it?
Well, again, my lord, all we're talking about here is the general starting point in the general case. So there may be.
That's the reason for asking the questions, really.
But
that's one of the points that troubles us as to whether it's right to say there should be a general starting in any case, as opposed to following the CPR.
Yes, well, that's where my submissions began as well, was that the CPR does set out a general position that the successful party gets his costs.
But in Lord's example, if the defendant accepts everything other than merits and fights the merits and loses after a 3-day hearing, it might be said that that's a sort of classic case in which it would be appropriate to order the defendant to pay the costs.
Yes. Well, I agree, and I don't think from what my learned friend says, he would disagree either, that all we're talking about is a starting point, and any particular factual situation, the order could go either way.
No, I think he would disagree. I think he would say, look at Picnic Ascot and Melford, that you can't have success and failure judged simply by reference to the particular hearing, because its success is only, as it was put in Melford, provisional success, and depends upon the validity of the claim. He would accept there may be special circumstances if you've wasted time and costs, but that's not going to cover all the cases where you may have an arguable case, but you argue it for 3 days and you lose. And in other contexts, if you had a case management hearing which went on for 3 days and you lost, you might have had perfectly sensible arguments and you fail, you would be regarded as having to pay the costs as the unsuccessful party. And you would have thought to be able to say, well, of course, this all depends, if you're the defendant, it all depends on whether the claimant gets home at trial. But there's the problem with on his case with the logic of where it takes one.
Yes.
But on your argument, we do need to understand and reach a decision on what the starting point is. Yes. Not, well, of course, there may be circumstances which you can depart from it.
Mm.
Well, our case is very simple. The starting point is CPR 44.2, I think it is. That is whoever wins. That's the starting point. Yeah. And then one moves away from that starting point. And my understanding of the law is that there is a possible exception to that starting point in the specific context of American cyanamid interim injunctions because of the reasons for some of the cases my learned friend took your lordship through. So.
Do you have a submission? I mean, I understand that. You say, never mind what is the case in interim injunctions, yeah. Freezing orders are different.
Yeah.
I understand that. Suppose you're wrong about freezing orders being different. Do we then just apply the interim injunction, or do you say, well, actually, interim injunction is, as expressed in Picnic at Ascot and Melford, is actually too prescriptive?
I would say so. I would say it is too prescriptive because as your lordships have been giving me sort of unusual, maybe less unusual, or certain factual situations that push the rules around, so that if one has a starting point, one avoids actually having a sensible discussion about what the merits of the particular case is involved. So there's a danger of having a fixed starting points for particular types of relief when the factual scenarios can be very varied. So we would suggest that the proper approach would be just to start with CPR 44.2, and no doubt one would take into account the sort of features in Picnic at Ascot in an interim injunction case, and say therefore the just order in this sort of situation is reserved because there's no clear winner or something like that, but not to take that as a start.
It may be that a principled approach would be to say costs reserved is, absent special circumstances, the appropriate order if and when it is foreseeable at the interlocutory stage that the exercise of discretion as to costs in relation to the interlocutory hearing might be affected by the outcome of the trial. And it may well be, because in those cases, Duquesne and Melford, where it was considered that it would be unjust to make an immediate order for costs, it's on that basis, not because there's some general rule or that you can't have an assessment of success or failure on an interlocutory basis, but that's the principal starting point.
Yes, it may be, but I see that. But I think the CPR did introduce this idea of pay as you go, which is quite a sensible principle in theory, because it means it puts it creates an incentive for parties to be sensible as the interlocutory stage, and which was a problem in the pre-CPR days, that there would be these pointless interlocutory massive battles that wouldn't be resolved. The costs wouldn't be resolved to the end of the trial.
Well, it's not just being sensible, because if what happens is not sensible and the points are taken which shouldn't be taken and it's a waste of time, then that's not the problem we're here concerned with. That's outside the scope of the starting point. But the pay as you go is a bit more than that. It is, if you fight an interlocutory battle and you lose, and because it has taken up court time and other people's resources and so on, by and large you have to pay for it. That's the pay as you go, as opposed to you shouldn't take bad points, I think.
That's true. Well, I accept that, but then the point your lordship was saying was maybe you should reserve, even in that sort of situation, if the outcome of the trial will show that maybe there's a justice problem with ordering costs immediately. But there is a tension between that and the what's beneficial about the pay-as-you-go approach, is all I'm saying. So that there may well be many cases in which the eventual outcome of the trial might have caused the judge to think differently slightly about costs at an interlocutory stage, but there's still a policy reason to encourage a pay-as-you-go approach when that can be done in a fair way. So that's we say that a freezing injunction should be dealt with in just the way of any normal interlocutory application. And as your lordships made the point to my learned friend standing, and he wasn't able to answer it really, is why does his argument not apply to a disclosure application where the
any interlocutory application, any case management.
Exactly. Literally any interlocutory application, the defendant can say, well, you should never have sued me. When that's shown at trial, I should have my money. I shouldn't have had to pay you for this interlocutory application. But that is not the way English law works on costs. And the only exception to that has been the interlocutory injunction scenario. And that is for the particular reason that one sees in Picnic at Ascot, that this is a type of judgment that is holding the ring, and that is giving one party the relief that they're seeking on a temporary basis, pending the trial. And we say that just because a freezing injunction has the word injunction in it, it's different to an interim injunction and shouldn't be treated the same. It should be treated in the same way as any other interlocutory application. And we endorse the analysis of Mr. Justice Edwin Johnson in Harrington and Meta that my learned friend took you through. He reviewed the authorities very carefully, and we agree with the analysis that he set out.
Just remind us of where that is.
So that's in the authorities bundle at tab 40. And there's he reviews all the authorities in this area, starting at paragraph 8 of his judgment.
Yeah.
And then his analysis really is at paragraphs 26 to 30, which we would endorse and agree with, and onwards to paragraph 36. And he made the free shot point that we would agree with, that if costs were generally reserved on freezing injunctions, then there would be no incentive on defendants to act reasonably when faced with a freezing injunction. They would always know that even if they lost, whatever points they'd taken when they shouldn't have done, that they will not face a costs order until the end of the trial.
But he makes the point, doesn't he, that reserving the costs puts off the evil day so far as the defendant's concerned of being held responsible for having run up a huge cost bill at an interlocutory stage.
Yes.
Puts it off until trial, and as he says, of course, there may never be a trial at all. So it may be that at some stage there's some overall settlement where it all comes out in the wash, and so the defendant never actually has to take the consequences of what's happened.
Yes, of course.
That's the point he's making at paragraph 35.
And I would also draw your Lordship's attention to a paragraph that I don't think Mr. Margolin showed you, which was paragraph 37 of this judgment, which is on page 1018, where he was commenting on the specific facts of that case. But he said, if you have a situation, as in the present case, where a freezing order has been granted on a without notice application, and the respondent then launches an all-out attack on the freezing injunction on the basis of non-disclosure, it seems to be not unreasonable, at least as a matter of general starting principle, that the respondent should pay the cost of that attack if it fails. And we say that it doesn't really matter whether the all-out attack is on the basis of non-disclosure or some other factor, but if that is what a respondent does, then the starting point should be that they do pay the costs. Again, so that the authorities that your Lordships have and your Ladyship have been shown were a number of authorities, Picnic at Ascot and so on, to Ken, which said that in the context of interim injunctions, American cyanamide injunctions, the starting point is cost reserved. And then you were shown a number of freezing order cases which said, well, that doesn't apply in the context of freezing orders. And then there's one case which says the opposite, which is the Al-Assam case, which is the decision of Mr. Justice.
He's on a Malcolm Davis
That's
White.
right. Thank you. Yeah. So he is on his own here in suggesting that freezing injunctions should follow the Picnic at Ascot rules, and we disagree with his analysis for the reason that the judge gave in the Harrington case, and in particular, for example, if we can just pick up the Al-Assam case, it's at the Authorities Bundle tab 38, and at paragraph 252. So it's page 890 of the bundle, paragraph 252. The judge concludes that paragraph by saying that if the claim fails at trial, then the freezing injunction should, with the benefit of hindsight, not have been made. But that, with respect, is an error. And that's the error that, in the same category as saying, well, if the claim fails at trial, then the disclosure application should not have been made.
Or the interim injunction.
Or the interim injunction, that's true. But the fact that because you've lost at the trial, you shouldn't have got any interlocutory relief at all is just a flawed logic. That seemed to be a point that the judge in that case considered important, but was wrong, we say. And in short, we say the right approach to the costs of a resisted freezing injunction is that in Harrington and the cases that preceded it, and that Al-Assam is an outlier, which is wrong. So was my second limb of my argument on costs. The third limb is that in any event, the judge exercised the discretion correctly, and I can do that just by looking at the judge's decision, which is in the core bundle at tab 9. And as the court's well aware, Mr. Justice Bright made it clear in paragraph 8 that he was making his decision on a fact-based or an exercise of his discretion rather than applying any particular rule one way or the other. And we say that the decision he made was correct. Unitel applied. We applied for this freezing order, as your lordships and ladyship are aware, on notice. There was no ex parte application here. We applied on notice properly. It was listed with regard to Mr. Santos's convenience. She had a very long time to decide how to respond to it, over a year as it happened, thanks to listing taking a very long time. In that time, she chose not to offer any undertakings. Instead, she fought every limb of the freezing injunction, and she lost on every one. We had to prepare and conduct a fiercely fought 2-day hearing. We had to argue issues of law and fact, and indeed, because of the choice they made to argue good arguable case, requiring better of the argument, and to dispute the existence of good arguable case, there was a more searching investigation than usual into the merits on Angolan law and so on. And so we would endorse what the judge says at paragraph 6 of his judgment, that Mr. Santos bears more responsibility than usual for the costs of this freezing injunction. So we say the judge's decision was correct and was certainly a decision within his proper discretion with which this court should not interfere. Unless I can assist further, those were my submissions.
Thank you.
My Lord Smiley. We say it's quite clear that the judge's approach to the question of costs started from the wrong place, and that this court is entitled to exercise his discretion afresh. So far as that discretion is concerned, the matters which are adverted to in the judgment are, first of all, paragraph 5, the fact that the application was made on notice. That's not in my submission a factor which takes this outside the norm and justifies making something other than the usual order, which we say would be cost reserved. Secondly, paragraph 6, the notion that because we were arguing that the good arguable case test involved a relative assessment, there was a relative assessment, and that's how the judge approached the merits. That's not, in my respectful submission, something which should take the case outside the norm in terms of costs either. And where he says in paragraph 7 that there was, for that reason, a more demanding examination of the merits, what of course there hasn't been, is a determination of the merits on the balance of probabilities as at trial. And so the absence of a winner or loser, that point as made in Picnic at Ascot and Melford, holds good in this case. So that's the first point. The second point is, and it's been put in a variety of ways now, tooth and nail, all out attack, fought every limb, fiercely fought. If resisting an application for an injunction doesn't mean that one departs from the usual rule of costs reserved, then it's my submission that unless a party's behaved unreasonably, and that's not this case, unless a party's behaved unreasonably, a party should be able to fight his case fully. Otherwise, one finds oneself in a situation where, and as I say, I'm not talking about parties who behaved unreasonably, but parties that feel, well, I've got to conduct my resistance to this injunction application with one arm tied behind my back because I don't want to give the impression of taking every point because that's going to sound against me in costs. That's a very undesirable place to end up.
That's unreal, Mr. Martin, because if you had a disclosure application which your client had chosen to oppose and lost, the chances are your client would have been ordered to pay costs straight away in accordance with the usual principles applicable to that sort of interlocutory application. The idea that somehow you've got both hands tied behind your back, or even one hand tied behind your back, doesn't seem to me to be a particularly compelling argument.
Well, my Lord, just picking up on that, and picking up on my Lord Justice Popplewell's questions about, for example, a disclosure application. It may well be that an important difference between, on the one hand, freezing injunctions and sign-of injunctions, and on the other hand, case management decisions, disclosure, and so on, is that in the latter, there's no element of holding the ring. My submission is that if one looks at the authorities, it's Decane and so on, there is a focus on a combination of two things, really, one of which is holding the ring, the other of which is that one doesn't know who the winner and the loser is because all of this is subject to what is decided at trial on the merits. And it may well be that that's at least part of the answer to the question, well, where does one draw the line, and does my argument extend so far as things like disclosure applications? And in terms of this case having been fought on issues of law and fact and so on, and in terms of what the judge said about undertaking a relative assessment in terms of the good arguable case test, there were, of course, conflicting lines of authority, and the judge himself acknowledged that conflict was something which needed to be resolved at appellate level, and of course permission was given. So, as I say, this is not a case which should be approached on the basis that the appellant has behaved unreasonably. The appellant unsuccessfully resisted the application, but that is not tantamount to behaving unreasonably. Next point, very quickly, my learned friend was talking about reliance on the pay-as-you-go principle, and that being something which follows as a matter of generality from CPR 44.2. But of course, that's the very point, the very argument that was rejected expressly in Melford. And then my penultimate point is this. It seemed to be suggested by my learned friend that in the freezing order context, the applicant has an existing right which is being established at the stage of the grant of the freezing order. If that is his submission, then with respect, we don't agree with this. Clearly, both in the freezing order context and in the context of cyanamide injunctions, what's happening is that a right which has not yet been established is being vindicated. Whether that right is going to be established as in the American cyanamide context at trial, or whether in the freezing order context that right is going to be established at the enforcement stage, doesn't matter and shouldn't, we say, having any bearing on costs. And just 2 points on that. Nobody has a right to interfere with someone else's property and that person's entitlement to use their property unless it's established at trial. The second point is this. paragraph 89 of Convoy, the interest protected by a freezing injunction is the brackets usually prospective right to enforce through the court's process. Of course, it is usually prospective, unless, of course, it's a post-judgment order. And then my final point is this, and I offered this up very briefly at the end of my submissions by reference to the Australian authorities. If you're against us on cost reserved, then to ensure that the claimant doesn't end up paying the costs of the application, if that is something which the court is anxious to do, then I'd respectfully suggest in the alternative that the right order would be claimant's costs in the case. But my primary submission obviously remains that costs should be reserved, and one should see what happens at trial in relation to the question of whether or not the claimant has a good case or a bad case. And that's the principle which underpins the case law from Decane through to Melford Capital. Unless my lords, my lady, you've anything to raise?
Great, thank you very much indeed. Thank you. Well, thank you all very much indeed for extremely well argued case. You won't be surprised to hear we're not going to be able to deliver judgment by next Wednesday, but we will endeavour to get you a draft judgment as soon as possible in the new term, and if not before, but I'm not going to make any promises. When you get the draft judgment, please pay attention to the terms of the embargo at the top of it, in the sense of who has access to it. And just a reminder that the idea is to provide us with any typographical errors, not to invite the court to rewrite the judgment. But apart from that, as I say, thank you all very much indeed. And I know it's always a team effort, so it's not just those who've actually engaged in the advocacy, but the other members of the team all around. And it only remains to, if you are having a summer holiday, to wish you a very happy one.
All rise, table.